Good evening, students. I'm Rohit, and today we have to start with the remaining articles. Okay, so in the last class, we have completed Article 15. We completed two clause of Article 15, that is Article 15 Clause 1 and Article 15 Clause 2. Now we have to cover the remaining four clauses of Article 15. So let us start with Article 15 Clause 3. Now remember, in the first clause of Article 15, we discussed that the state shall not discriminate against any citizen on those five grounds. And in the second clause, we discussed that no citizen shall be subjected to any restriction, condition, liability, or disability with regard to the access to the shop, public restaurant, or hotel, or the use of well, bathing ghat, roads, etc. Okay, so this was the second clause of Article 15. And now remember, the remaining four clauses of Article 15 are considered as an exception to Article 15. So whatever we will study right now will be considered as an exception to Article 15. Okay, so let us discuss the exceptions to Article 15. Okay, so the first exception to Article 15 is Article 15 Clause 3. Now remember, in 15 Clause 1 and 15 Clause 2, we discussed that the state shall not discriminate against any citizen on the ground of religion, race, caste, sex, place of birth. So we discussed sex as the ground the government should not discriminate against any citizen on the basis of sex. I mean, there should be no discrimination between men and women. The state should made laws which are equally applicable to men and women. But the fact is, according to Article 15 Clause 3, the state is empowered. The state has the authority to make laws for the advancement of women and children. It means a state can make such laws which only benefit the women and not men. For example, we have seen many schemes launched by the government which specifically target women. For example, many political parties or many government promises that once we come to the power or once we are elected, we will deposit 1,000 rupees, 2,000 rupees, or 2,500 rupees in every women's account of that particular state. Or we have decided to give free two-wheeler to women or girls, college-going girls, or we have decided to distribute free laptop to girls. Why only girls? Why only women? I mean, why there is no benefit which is given to the men? It is because, according to Article 15 Clause 3, the state is empowered. The state is empowered to make provisions. The state is empowered to make provisions for the advancement of women and children. So whenever you see that the government has launched a scheme which is specifically for women, then you must understand that this cannot be considered as discrimination on the ground of sex, but it is rather a special provision for the advancement of women. See, women are historically considered as a backward section, oppressed section. Yes, women are considered as historically oppressed section. Okay, because of various tradition and customs, all the restrictions were imposed upon women. Yes, fundamental rights can be amended. You have asked the question. Yes, fundamental rights can be amended, but they can be amended only under Article 368 by simple law. You cannot amend fundamental right. Okay. So I hope this thing is clear, that the government can make a special provision for women and children. And remember, you must have seen that even in public transport, there is a seat reserved for women. Even in metro, you find the first cart in the moving direction is reserved for women. You also see that there is fees exemption when women applies for government job. Then while filling the form, they do not have to pay the fees. So there are many provisions which government can make for the advancement of women, considering them as oppressed and backward section. Okay, and even if suppose tomorrow, if government decides to reserve 50% seats for women in government job, then remember, if this happens, that 50% of government jobs are reserved for women, then also you cannot say that this is a discrimination. This is an advancement. This is a special provision for the advancement of women. So giving reservation to women in government job, and right now we have seen that a law has been passed providing reservation of seats in the legislature. We have also seen that by the 73rd and 74th Amendment Act, 1/3 seats were reserved for women in panchayat and municipality. These all are considered as the special provision for the advancement of women. Recently, Delhi government has introduced a free ride for women in public transport, especially buses. Special provision for children, yes. The state shall provide free and compulsory education to children between 6 to 14 years of age. So not above 14 years of age, but children between 6 to 14 years of age are entitled to get free education from the government, that too quality education. Okay, so this is Article 15 Clause 3. So now I hope it is clear that why this article is considered as an exception, because on one side we discussed that there should be no discrimination on the basis of sex, but on the other side we are saying that, on the other side the same article is saying that the state can make a special provision for women. Okay, so now let us see Article 15 Clause 4. So one thing you have to remember about Article 15 Clause 4 is that this article has been added by First Amendment Act of 1951. Originally in the Constitution there were only 3 clauses for Article 15. 15 Clause 1, 15 Clause 2, 15 Clause 3. So the 4th clause was added by the First Amendment Act of 1951. Now what was in this clause? See, this clause empowers the state to make special provisions for socially and educationally backward classes, SC and ST. Okay, so this particular article empowers the government to make a special provision for socially and educationally backward classes, ST and ST. Now remember, other backward castes, OBC, is not mentioned in Article 15. In fact, the Constitution uses the expression socially and educationally backward classes for OBC. We call them as OBC, other backward class. But in reality, according to Constitution, they are socially and educationally backward classes. So instead of OBC, we are writing socially and educationally backward classes. So this particular article deals with a special provision for SC, ST and OBC. But remember, here we are discussing about the special provision which do not include reservation in government jobs, because reservation in government jobs is dealt under Article 16. So under Article 16 we will discuss that what are the special provisions in government job for SC, ST and OBC. But right now we must understand that here special provision means, for example, this this particular clause can include providing reservation in colleges, or that is educational institution. We all know that there is a reservation for SC, ST, OBC in educational institution. So with the help of this article, the government can provide reservation in educational institution. And also sometimes the government exempt SC and ST from paying fees while filling the government form. Many times this happens. There are many provisions, or there are many times this has happened that SC or ST community are not required to pay fees while filling the form. Government give them a scholarship. So these all are these special provisions for the advancement of these backward section. So this was Article 15 Clause 4, which was added by First Amendment Act of 1951. And after this, the government in 2005 added Article 15 Clause 4. Now let us see what is Article 15 Clause 4. Sorry, Article 15 Clause 5. So Article 15 Clause 5 was inserted by the 93rd Amendment Act of 2005. Now, according to this article, the state is empowered to make special provisions for SEBC, basically OBC, ST and SC with regard to admission. So now this particular clause is related with reservation in educational institution, because this article is specifically saying that there can be reservation for SC, ST and OBC in admission. And where this admission is? This admission is in educational institution. In educational institution. So government can provide reservation in educational institution. Now when I write educational institution, here educational institution means both, either public educational institution or private educational institution. In other words, private college or government college, it doesn't matter. Reservation can be provided in both the category, public or private. One more thing, it doesn't matter whether the government is providing the aid to the college or not. So be it public or private, or aided or unaided, aided or unaided, it means whether the government is providing aid to the college or not. So whether it is public or private, aided or unaided, reservation can be provided in such educational institution. But there is an exception. Reservation can be provided in these educational institutions except minority educational institutions. Now this is important, that you have to remember where the reservation cannot be provided. So the reservation can be provided in government college, private college, whether they are receiving aid from the government or not, but the reservation cannot be provided in minority educational institution. Those educational institutions which are established by the minority community. Okay, there the reservation cannot be extended. Okay, so this is Article 15 Clause 5 is specifically dealing with the reservation in colleges. So, and I said this earlier, that reservation in government jobs is dealt in under Article 16. So here we are discussing about the reservation in colleges. Okay, so this is Article 15 Clause 5. Now, and remember, in order to enforce this particular clause of Article 15, the government enacted Central Educational Institution Reservation in Admission Act. Now, this particular act was enacted somewhere in 2007, and because of this act, 27% reservation was provided to OBC in all the central educational institutions, including IITs and IIMs. This caused a massive uproar at that time in 2007 and 2008. There was massive uproar in the entire country regarding the reservation, especially to OBC, that to 27%. So 27% reservation was given to OBC in central educational institution. This was done to enforce this particular clause of Article 15. Okay, so this was Article 15. But remember, reservation is not limited to SC, ST and OBC. According to the Constitution, the reservation can also be provided to general category belonging to poorer section. I mean, those who are from general caste but belong to poorer section can be given reservation in the colleges. So right now we will discuss that. So you all know that recently EWS category, economically weaker section, have been provided the reservation in colleges and government job. So which particular clause of Article 15 deals with the reservation to EWS category? It is Article 15 Clause 6. So remember, Article 15 Clause 6 was inserted by 103rd Amendment Act of 2019. So remember, this particular amendment is important for reservation in educational institution for EWS category. So because of this amendment, the state can provide 10% reservation. The state can provide 10% reservation to EWS category in educational institution. In educational institution. And all the same condition, whether that educational institution is public or private, whether it is receiving aid from the government or not. Okay, except minority educational institution. Except minority educational institution. Okay, so I hope this particular thing is clear, that which amendment of the Constitution is responsible for giving reservation to EWS category. Now remember, who are EWS? Those EWS represents that section of general category which earns less than 8 lakh per annum. So the family income should be less than 8 lakh per annum. Only then you will be considered as EWS category. And there are other criteria as well, okay, for EWS category. So similarly, there is a concept of creamy layer in OBC. If you're earning, if you're earning more than 8 lakh per annum, if the income of your parents is more than 8 lakh per annum, then you are considered as creamy layer in OBC. However, the government is deciding to revise this limit, and the government might raise this limit to 12 lakh instead of 8 lakh at present. So this particular amendment provides reservation to EWS, that to 10%. Okay, so I hope with this we are done with article number 15. So in article 15 we have to study total 6 clause. The first 2 clause in general speaks about that there should be no discrimination on the ground of religion, race, caste, sex, place of birth, okay, especially in public places. But the remaining 4 clauses are actually exception. The first exception to article 15 is that the government can make a special provision for women and children, then for SC, ST and OBC, and at the last is it is for EWS category. Okay, so with this we are done with article 15, and now we can start with article number 16. Now remember, article 16 specifically deals with reservation in government jobs. Okay, this particular article deals with public employment. So what is the heading of article 16? The heading of article 16 is equality of opportunity. Equality of opportunity in matters of public employment. In matters of public employment. Now remember, here public employment basically means government jobs. So ideally, the article 16 is saying that everyone should have equal opportunity in matters of government jobs. Okay, so first we will start with the general matter contained in article 16, and then we will discuss the exception to article 16. So the first 2 clause of article 16 are in general in nature. I mean, they are simply saying that there should be no discrimination on the ground of those grounds, which we will discuss right now, and then we will discuss the exception to article 16. So first thing, under article 16 there are total 7 grounds on which there should be no discrimination in public employment. Okay, so those 7 grounds. Now remember, in article 15 we discussed the 5 grounds. Those 5 grounds were religion, race, caste, sex, place of birth. So there were total 5 grounds in article 15, but in article 16 there are total 7 grounds. So those 7 grounds are, see, the first 5 grounds are similar to article number 5, sorry, article 15, and that is religion, race, caste, sex, place of birth. So these 5 grounds were also discussed, or I mean these 5 grounds were also mentioned in article 15. So the starting 5 grounds are similar. The remaining 2 grounds are, the first is residence and the last is descent. Okay, so under article 15 there are total 7 grounds on which there should be no discrimination. I mean, the state should not discriminate against any citizen on these 7 grounds in matters of public employment. When it comes to the appointment in government job or posts in the government job, then there should be equality. So this is article number 16 is speaking about that there should be no discrimination in government job. So this was the general part of article 16, and now we will discuss the exception to article 16. So let us start exception to article 16. Exception to article 16. So the first exception to article 16 is article 16 clause 3, because whatever we discussed right now was under article 16 clause 1 and 16 clause 2. Now no one is going to ask in detail that what is 16 clause 1, what is 16 clause 2. We must understand that collectively these 2 clauses are saying that the state should not discriminate against any citizen on these 7 grounds. Simple. But now we will discuss a few clauses in detail. Okay, so the first is article 16 clause 3. So according to article 16 clause 3, only parliament has the authority, only parliament has the power, or only parliament has the authority. Authority for what? Authority to prescribe to prescribe residence as a condition, to prescribe residence as a condition for employment in any state or union territory or any local authority or any other authority Now remember, this particular clause empowers the parliament to prescribe residence as a condition for providing for providing residence as a condition. For example, suppose a particular government passed a law saying that from now onwards, 70% of jobs in our state are going to be reserved for our people. So suppose you belong to the state of Uttar Pradesh or Madhya Pradesh, okay, and what happened? The state of Madhya Pradesh passed a law, and according to that law, only 70% or 80% of jobs in Madhya Pradesh will be reserved for the people of Madhya Pradesh. I mean, those who are the resident of Madhya Pradesh, they will be given reservation in jobs. So here the reservation is given on the basis of residence. If you are a resident of that state, then you will avail the benefit of reservation. Okay. It depends upon the government whether the reservation is 50, 60, 70. Suppose government says that 60% of all the jobs in our state will be reserved for the resident of these states of the state. Okay, so this is the residence as a condition. But remember, as per Article 16 Clause 3, only the Parliament has the power to prescribe residence as a condition for certain employments. But the fact is, many times in our country, states also make such provision requiring residence as a condition for certain employment. Ideally, this is the job of the Parliament to prescribe residence as a condition. But many times, the state government also pass such law, thereby questioning their validity. That whether the state government is empowered to prescribe residence, because under Article 16 Clause 3, only Parliament has the authority. There is no mention of the state, whether the state has the authority to provide reservation on the ground of residence in that state. Okay, so this was Article 16. Now, after Article 16 Clause 3, we will discuss the most important clause of Article 16, and it is Article 16 Clause 4. Now, this is the most important clause of Article 16, and it is Article 16 Clause 4. This particular article deals with that the state has the power to provide reservation in government jobs to backward classes which are not adequately represented in the service. Okay, so Article 16 Clause 4 says that when it comes to the backward classes, Article 16 Clause says that when it comes to backward classes, the state has the authority to give reservation in government job to the backward class. So here the word backward class is used. So you can assume that backward class automatically includes SC, ST and OBC. So see, in Article 15, it was specifically mentioned that SC, ST, SCBC, but in Article 16 only the backward class is mentioned. So but we can assume that SC, ST and OBC are also included in backward classes. So this particular clause of Article 16 deals with reservation in government job. Whether it's appointment or whether it's post in the government job, the reservation can be extended to the appointment or post in government job, that is public employment. So now keeping this article in mind, we will discuss about the reservation given to OBC, especially in 1990 by BPSC government. So right now we will discuss about the background, that how OBC were given 27% reservation government job. So for this we have to understand what was Mandal Commission, what was Article 340. So only when we will understand that what is Article 340, why Mandal Commission was appointed, then we can understand that why 27% reservation was given to OBC. So let us first discuss Article 340. Okay, so right now we are discussing the background of 27% reservation to OBC. So let us start with Article 340. So what is Article 340 of the Constitution? According to Article 340 of the Constitution, the president shall appoint a commission. So under Article 340, the duty is of the president to appoint a commission. To appoint a commission. Why? Why this commission? Now the task of this commission will be to investigate. To investigate. To investigate what? To investigate the conditions. Conditions of socially and educationally backward classes, and to suggest measures for their advancement. So remember this thing, that Article 340 expects from the president that president from time to time should appoint a commission for investigating the conditions of socially and educationally backward classes, which basically means OBC. Okay, because the constitution has used socially and educationally backward classes for other backward classes. Okay, so instead of OBC, we find this expression for OBC. Okay, so this particular article is responsible for the appointment of backward commission. So under Article 340, I mean, according to Article 340, the President of India for the first time appointed the backward commission. So the first backward commission which was appointed by the President under Article 340 was the first backward commission. So the first backward commission was appointed under Article 340, and the first backward commission was appointed in 1953, and the chairman of this commission was Kaka Kalilkar. I'm not sure whether this commission was appointed in 1953 or 1955. I'm somewhat confused with regarding year, whether it was appointed in 1953 and submitted its report in 1955, or whether it was appointed in 1955. But I'm right now confused with it. But what you can remember is that the first backward commission was appointed by the president under Article 340, and the name of this commission is First Backward Commission. So the chairman of First Backward Commission was Kaka Kalilkar. But remember, the report of this commission was not, the report of the commission was not implemented by the government. So we do not have to remember what were the recommendations in the report given by the commission. So what we have to remember, that the backward commission is appointed under Article 340, and the chairman of First Backward Commission was Kaka Kalilkar. Because the report was not implemented by the government, so we do not have to discuss this particular report in detail. So let us just ignore this fact, and now moving on to the second backward commission. So in 1979, the President of India under Article 340 appointed second backward commission. So the second backward commission was appointed in 1979. This happened during Janata government rule. I mean, at this time, the Prime Minister was Morarji Desai. So when Morarji Desai was the Prime Minister of the country, he appointed a commission that was Second Backward Commission. So Second Backward Commission was appointed during the rule of Janata government in 1979. So the chairman of this commission was BP Mandal. BP Mandal was a member of parliament. So this commission is also known as Mandal Commission. This commission is also known as Mandal Commission. So the second backward commission is Mandal Commission, and this was appointed by Janata government in 1979. Okay, so now remember, this commission is important for your examination. Now why I am saying it is because of this commission that the government finally gave 27% reservation to OBC. So let us first discuss what the commission observed and what commission recommended. So this commission submitted its report in 1980. So in 1980, this commission submitted its report, and in this report, what the commission observed. Now let us understand the observation in this report. So the first thing, according to this commission, there are total 3,743 castes which are basically OBC. So in India, there are total these many castes which are OBC, and they constitute 52% population. Okay, so basically OBC constitute half population of a country. Okay, so OBC constitute 52% population. and there are total 3,743 castes. So according to Mandal Commission, if we really want to do something for the OBC, if we really want that the OBC should also advance, if we for the advancement of OBC, what Mandal Commission recommended? Mandal Commission found that already 15% reservation is given to SC, ST enjoys 7.5% reservation, and Supreme Court in 1963 said that the total reservation cannot exceed more than 50%. So it was somewhere in 1963 that the Supreme Court said that the total reservation should not exceed more than 50% in any given year. So Mandal Commission was aware of this fact that the total reservation cannot exceed more than 50%, and already 22.5% reservation is enjoyed by SC and ST. So how much is remaining? So the remaining percentage is 27.5% remaining. So only 27.5% reservation is remaining. Okay, otherwise it will violate the direction of Supreme Court in 1963. So of 1963. So what happened? Mandal Commission realized that OBC constitute 52% of Indian population. But we cannot give 52% reservation to OBC because they are 52% in population. So what Mandal Commission did? Mandal Commission restricted to 27% because we cannot give reservation to OBC that is more than 27.5%. So what Mandal Commission said? Mandal Commission said that we can give 27% reservation to OBC in government job. Therefore, the total reservation will be 49.5%. It means it will not cross 50% limit prescribed by Supreme Court in 1963. So the most important recommendation of the second backward commission was that the OBC should be given 27% reservation in government jobs. And now you know that why only 27% reservation should be given to OBC. Why not 28%? Why not 29%? Or why not 50%? Because in 1963, Supreme Court said that you cannot give reservation more than 50% in any year. So already 22.5% reservation was given to STHT. So remaining was 27.5%. So that's why the commission restricted itself to 27%. So this is the story behind the 27%. Why not 28, 29, 30 or 50% reservation to OBC? So this was the report of this was the report of Mandal Commission. And remember, the report was submitted in 1980. By that time, Indira Gandhi government came to power. Indira Gandhi assumed power. So Indira Gandhi government discarded the report of Mandal Commission. Okay, so Indira Gandhi government did not enforce the report of Mandal Commission. So this report was remaining. This report remained idle for around 10 years. For 10 years, this report was gathering dust, and it was only after 10 years, in 1990, that the government of that time decided to declare a 27% reservation to OBC in government job. So it happened after 10 years. After 10 years, that is in 1990, VP Singh assumed power. So VP Singh became the Prime Minister of the country, and he tried to play the OBC card. So in order to woo the OBC section, he declared that yes, we will implement the Mandal Commission report. So it was the VP Singh government which declared. Now this is important for you, that which government. See, Mandal Commission was appointed by Morarji Desai, but when the report was submitted by the commission, at that time Indira Gandhi came to power. So this report was idle for 10 years. So it was in 1990 when the VP Singh government decided to play OBC card and declared that we are going to implement the Mandal Commission report. We will give 27% reservation to OBC. So it was the government of VP Singh which declared that we will give 27% reservation to OBC as per Mandal Commission recommendation. As per recommendation of Mandal Commission. So I hope now you all will remember that which government declared 27% reservation to OBC. It was VP Singh government. But which commission recommended 27% reservation? It was Mandal Commission, that is second backward commission under Article 340. So this happened in 1990. Now what happened? in 1991 or in 1991 and 1992, PV Narasimha Rao assumed power. So in 1991 and 1992, PV Narasimha Rao became the Prime Minister of this country, and when PV Narasimha Rao became the Prime Minister, see, one thing you have to remember, it is very easy to give reservation. I mean, to declare that OBC will be given 27% reservation government job, it is easy to say, okay. But the fact is that once you declare or once you give reservation, it is very difficult to roll it back. So now, if any government tries to roll back reservation, then that government will be considered as anti-OBC. So VP Singh government said that we will give 27% reservation to OBC. But now it is next to impossible for PV Narasimha Rao government to roll back reservation. You cannot take that 27% back from OBC. Why? Because now the PV Narasimha Rao government will be considered as anti-OBC. So what PV Narasimha Rao government did? PV Narasimha Rao said that, okay, we have no issues with the 27% reservation to OBC. We have no issues with that. But we have one issue. Not all OBCs really require reservation. So what PV Narasimha Rao said that only the poorer section amongst the OBC should enjoy the benefit of 27% reservation. So what PV Narasimha Rao said that in OBC, only those section will get 27% benefit, those who are poorer section among OBC. So only the poorer section among the OBC will enjoy the benefit of 27% reservation. So not all OBCs require reservation. Only those who are poor requires reservation of 27%. Now one more thing PV Narasimha Rao said. PV Narasimha Rao thought that okay, SC enjoys 15% reservation, ST enjoys 7.5, OBC 27%. What about the general category? So for Narasimha Rao, even the general category requires reservation in government job. So what Narasimha Rao government did? Narasimha Rao government said that the poorer section amongst the general category should be given 10% reservation in government job. So it was the Narasimha Rao government which decided to give 10% reservation to general category, but only those who are poorer. Okay, so the poorer section among the general category should be given 10% reservation. Now remember, there were already 49.5% reservation was given to SC, ST and OBC. Now what Narasimha Rao did? He gave 10% reservation to general category. So now the total reservation is 59.5%. So with this, the total reservation reached 59.5%, including that 10% reservation given to general category. So because of this, and because of this, there was a furore in the entire country, and that is why there were many cases filed in the Supreme Court regarding the reservation given to OBC. So what happened? The Supreme Court heard this case, and the name of this case was Indira Sahani. The name of this case was Indira Sahani versus Union of India So in this case, the Supreme Court examined Article 16 Clause 4, and upon examining the Article 16 Clause 4, the Supreme Court said that giving reservation to OBC, and that to only the poorer section, is constitutionally valid. So the Supreme Court upheld the constitutional validity of the act of the government. So the government decided to grant 27% reservation, that too only to poorer section. The Supreme Court found this particular provision as constitutionally valid. So Supreme Court upheld this provision, but in this case Supreme Court rejected this provision that general category should be given 10% reservation in government jobs, because see, in Article 16 Clause 4, expression backward classes is used. So for Supreme Court, you cannot be considered as backward only on the basis of economic factors. Just because you are poor, it doesn't mean that you are backward. Here, the social angle is also important. I mean, you should also be, you should be socially backward as well. So economic factors alone cannot decide whether we have to give reservation or not. There should be some social backwardness associated with the caste. And when it comes to social backwardness, there is that issue was never with the general category. Okay, they were always considered as upward caste. Okay, so this what Supreme Court said in Indra Sahni case. And one more thing, Indra Sahni case is also known because in this case, Supreme Court reiterated that the total reservation should not exceed more than 50%. Okay, so in this case, Supreme Court further said that total reservation should not exceed more than 50%. In fact, there are many more. There are many more recommendations given by the Supreme Court in this particular case. So, one of the point that Supreme Court said was that the total reservation should not exceed more than 50%. Other thing, one more thing Supreme Court said was that there should be no reservation in promotion. Reservation should be confined to initial appointment. Then there should be a committee to determine what will be the criteria for determining the backwardness. I mean, what will be the criteria to consider a particular section as creamy layer in the OBC? So for this, a committee should be appointed. Similarly, there should be a statutory commission for considering all those castes which should be given the benefit of reservation and which should be excluded from the benefit of reservation. So all these recommendations were given by the Supreme Court. These cannot be considered as recommendation. These were the guidelines or part of judgment issued by the Supreme Court in Indra Sahni case. So the most important thing in Indra Sahni case is that the Supreme Court laid down the criteria of 50%. The total reservation should not exceed more than 50%. However, in this article, there are many more things to discuss. After this, we also, we also discuss the actions taken by the government upon the recommendation of the Supreme Court. So we don't have to discuss that in detail. So we are done with Article 16, Clause 4, including the background of OBC reservation. And we are not going to discuss this particular clause in detail. Okay, because these kind of details are asked only in higher examination. For example, those who are preparing for state civil service or union public civil, those are preparing for UPSC or state PSC. For them, this particular thing is important, that what were the actions taken by the government. Okay, so we do not have to discuss that in detail. So I think we are done with Article 16 Clause 4. And now we will straight away jump to Article 16 Clause 6, leaving Article 16 Clause 5. That is not important. That is related to somewhat religion, religious denomination. A particular head of that religious denomination should be from that religion. So we do not have to discuss that religion. So what will happen? We will straight away jump to Article 16 Clause 6. And now remember, Article 15 Clause 6 deals with reservation to EWS category in colleges. So 16 Clause 6 deals with giving reservation to EWS category, that to 10% in government jobs. Okay, so this this particular clause was added by 103rd Amendment Act of 2019, and by this amendment, under this clause, it is clearly mentioned that EWS category will be provided 10% reservation in government jobs. So now we all know that by the 103rd Amendment Act, Article 15 Clause 6 and Article 16 Clause 6 were inserted. Article 15 Clause 6 deals with giving 10% reservation to EWS in colleges, whereas Article 16 Clause 6 says that 10% reservation should be given to EWS category in government jobs. Okay, so both these provisions were inserted by 103rd Amendment Act of 2019. So with this, we are done with Article 16. We only discussed the important provisions of Article 16. You should not believe. You should not think that we discussed the entire Article 16 entirely. We have discussed only what is relevant for your examination. You are not preparing for civil service examination, so we do not have to discuss all the important cases related to Article 16. There are many cases in Article 16, but those cases are studied by those who are preparing for judiciary, those who are preparing for law. Those who are preparing for state civil service or UPSC. But for you, those cases are not at all important. Okay, so after Article 16, we will start with Article number 17. Okay, so Article 17 is, see, for your examination, Article 17 is important. Article 17 is abolition of untouchability. Abolition of untouchability. And I have seen this many times that this question has appeared in the examination. And the question is, Article 17 deals with four options, or abolition of untouchability is under which article of the Constitution. So the heading is also important, that Article 17 deals with abolition of untouchability. Okay. So according to Article 17, untouchability, I mean, is prohibited. Okay. The Constitution has prohibited untouchability. Okay. So according to Article 17, untouchability is over. And remember, under Article 17, untouchability is an offense. So if anyone who is practicing untouchability, trying to impose condition or restriction upon a person of a particular caste, then that person shall be punished by law, and that law will be made by the parliament. So under Article 17, untouchability is abolished. So Article 17 has abolished untouchability. Abolished untouchability. But it is easier said than done. Okay. Why? Because see, it is simple to say that we have abolished untouchability. But how come you are going to alter the minds of people? See, the caste has taken deep roots in the minds of people. So people are not going to, they are not going to, consider everyone as equal. See, especially in rural areas and backward areas, you will notice that the untouchability is still practiced, and it is because of the weak law enforcement. See, there is a law that untouchability is a crime, but still untouchability is practiced in many parts of our country, especially in rural areas and backward areas. So why this happens? Because first of all, we have weak rule of law. I mean, the police are responsible for enforcing law, but usually police also somehow tries to perpetuate the caste system. Okay, they also sometimes discriminate with the people belonging to lower caste. So this happens, and this is something common in our country. This is not something I'm blowing out of proportion. This is something which is evident, that even sometimes those who are responsible for enforcing such laws are also found guilty of practicing untouchability. So, for example, panchayats are elected by the people, but still they somehow reinforce the caste system. So it is easier said than done that we abolish untouchability, but the fact is that untouchability is still a fact in our country. Okay, and in many parts of our country, you will find that untouchability is practiced, and the those who are practicing untouchability are not punished at all, because they belong to higher caste. They are somewhat, they enjoy the benefit of it. They get, there are many things not to discuss. Okay, so according to Article 17, the untouchability is abolished. And one more thing, uh, untouchability is not defined in Constitution. Now, suppose this statement comes in the examination that untouchability is defined in the Constitution. Remember, untouchability is not defined in the Constitution. See, when I say the word untouchability, you should not mean that I cannot touch anyone. See, the word untouchability should not be taken in literal sense. It means, see, during coronavirus, uh, what the government was saying, that you should not touch anyone, you should maintain a distance. Okay, so during coronavirus, everyone was practicing untouchability in literal sense, that you were not touching anyone because you know that if I touch that person, I might be infected with that virus. So what you were trying to do, you were trying to maintain distance from anyone. Okay, be it your family members or your friends or any stranger, you were trying to maintain distance. Why? Because you know that this disease is going to spread just because of a touch or even through air. So during coronavirus, everyone was practicing untouchability, but that untouchability cannot be considered as the untouchability under Article 17. According to a high court, I do not remember the exact whether it was Mysore High Court or Madras High Court. One of the high court said that the untouchability under Article 17 does not mean that you cannot touch anyone. Here, untouchability should be understood in Indian context, especially related to caste system. So this is a tradition of practice which has developed over thousands of years, that the members of a particular caste were treated as untouchable. So according to that High Court, here untouchability should not be taken or understood in literal sense. Here the untouchability should be understood in Indian context, related especially the caste system. Those who were considered outside the caste system were treated as untouchable. So few things that you have to remember in Article 17 is: the first, the heading of Article 17, abolition of untouchability. Second, Article 17 abolishes untouchability. I mean, that is understood with the heading. Second, untouchability is an offense, and anyone who is practicing untouchability will be punished as per the law made by the parliament. And the third thing, that the untouchability is not defined in the constitution, but a particular high court has clarified that here the untouchability should not be understood in literal sense. It is related to caste system. Okay, so with this we are done with article number 17, and the remaining articles will be completed in the coming classes. So tomorrow we will discuss article number 18. See, article 15 and 16 were lengthy, but in the next class we will discuss article 18, which is short. Article 18, 19, 20, 21, most probably, I mean, we will be completing 4 to 5 articles in the next class, because as I said that this particular topic is time consuming. So okay, so we are done for the day. Okay, so today we have completed article 15, 16 and 17, and tomorrow we will be starting with article number 18. Okay, so thank you everyone.